Hello, this is Law and Terrorism, the podcast series. I'm your professor, Glenn Torres-Spelliscy. Thanks for joining me. Thanks for joining me for this week's edition of 5 Key Questions. The topic this week relates to how the United States used its domestic criminal justice policy, as well as a newly constructed military justice system, in the aftermath of the 9/11 attacks. So let's get started. The primary forum of criminal enforcement with respect to crimes of alleged terrorism has been domestic courts and tribunals. Indeed, this is how most terrorism cases play out. The individual is arrested and brought to trial in a domestic court, where he is charged with domestic crimes, which, with respect to terrorism, have generally incorporated international standards. Since 9/11, domestic courts have convicted over 600 individuals accused of terrorism offenses. Now, prior to 9/11, this was the exclusive method of dealing with those facing terrorism charges in the United States. That, however, changed in the aftermath of the 2001 attacks. The U.S. Congress passed new laws that provide the military with the power to detain and try suspects accused of terrorist offenses through military commissions that had loosened rules of due process. So far, though, those commissions have only held 8 trials in 20 years and can probably be judged to be a failure at this point. The U.S. Criminal Code has codified the various international subject matter treaties that we have discussed in the course. In addition to those crimes, one of the most widely used anti-terrorism statutes are what are known as the Material Support Statutes. Codified in 18 U.S.C. Section 2339, the Material Support Statutes criminalize harboring terrorists, providing material support for terrorist acts, and providing material support for terrorist organizations. Material support is broadly defined to include any sort of financial or other tangible support. Some of the primary objections to the use of the United States Criminal Code to prosecute and try terrorist suspects comes from a fear that the due process rights, established over the course of centuries and afforded to accused criminals in the United States, are too expansive with respect to foreign terror suspects, and would simply result in the release of dangerous people who would later harm American interests. And while accused terrorists have Miranda rights, a right to confront evidence and a right to receive exonerating evidence from the prosecution, courts have interpreted these rights in a way that seeks to balance them with national security concerns. For example, let's look at the Miranda Doctrine. The Miranda requirement does not prevent intelligence officers from interrogating a prisoner, without warnings, after his arrest or capture. Indeed, Miranda does not even prevent a police officer from asking questions and interrogating a suspect without first giving a Miranda warning. The Miranda issue is not about interrogation or questions in and of themselves, but rather it is about the admissibility of evidence obtained via such questioning in a court of law. What does that mean? That means that a police officer, an FBI agent, a CIA agent can question a terror suspect without first providing a Miranda warning for the purpose of intelligence gathering. Now, any statements made by that suspect may not be admissible in a civilian court should the government decide to prosecute the individual. But in many circumstances, the statements of the individual are not that important to the prosecution. Further, there are a number of exceptions to the admissibility of evidence obtained prior to the issuance of a Miranda warning. First, the military is exempted from giving Miranda warnings while on the battlefield. Second, Miranda allows for the admissibility of voluntary statements by the subject. Third, statements made outside of the context of interrogation, for example in public or in the press, will be admissible even without a Miranda warning. Finally, and perhaps most significantly in terrorist context, is the public safety exception, which could be used in terrorism cases to justify interrogation in the context of trying to find a bomb or stopping an imminent attack. Further, while a terrorist suspect does have the right to exonerating evidence and a right to confront evidence against them to test its credibility, there are a number of ways the law has developed to limit the chance that sensitive information will be disclosed in this way. In 1980, Congress passed the Classified Information Procedures Act, known as CIPA, which is intended to prevent the unnecessary disclosure of national security secrets, while balancing the defendant's right to a fair trial, including the right to confront and rebut certain evidence. Under SIPA, the judge first determines the relevance of the requested information in camera, which is a Latin phrase just meaning in chambers, and they do it without the presence of counsel. If the judge determines it is necessary for a fair trial that the defendant's counsel see the evidence, the judge can order the information to be disclosed in a substitute form, for example through summaries of evidence. If the court determines that the summaries are not an acceptable alternative, the court can order the disclosure of the documents provided it's to a defense counsel who has received appropriate national security clearances. However, that information may not be disclosed to the defendant. If the defense counsel decides that he would then like to introduce the information at trial, then under the Act, that defense counsel must meet with the prosecution and judge in an attempt to come up with a way to protect the confidential information, including potentially through the use of summaries. In some scenarios, a defendant may choose to represent himself in the case. In such circumstances, the court can appoint a special counsel for the sole purpose of dealing with classified information and representing the defendant's interests. As a result of the militarization of the fight against terrorism, a separate system of justice was developed to try individuals associated with Al-Qaeda and related entities. After a series of legal decisions, the Military Commission's procedures were formally established by congressional enactment of the Military Commission Act of 2006. The Obama administration imposed significant reforms on the 2006 law, and in October 2009 passed the Military Commissions Act of 2009. The MCA establishes military commissions to try what are termed unprivileged enemy combatants. These are enemy combatants engaged in hostilities with the United States who are not considered combatants under the laws of war, and for war crimes or other offenses. As for due process protections under the MCA, a lot of it is very similar to the domestic criminal justice system. The procedures for military commissions are based on the procedures for military courts-martials and are pretty similar to domestic courts and criminal justice systems, with a few exceptions. One, there's no requirement of a speedy trial, and self-incriminating statements are admissible even if the suspect was not warned that he had the right to remain silent. Hearsay evidence is potentially admissible. And although the 2006 MCA banned torture, it allowed for the omission of evidence obtained through coercive interrogation methods, including cruel and inhuman and degrading treatment, if the military commission determined the information was reliable. The 2009 law passed by the Obama administration took a much stricter approach, and entirely bars statements made as a result of cruel and degrading treatment. Other than those differences, many of the same due process rights exist. Why? Because our experience over the 300 years of the American experiment is that these due process rights work. These rights represent the best balance we can strike between the need to protect the rights of the accused and the need to protect society from harm. Well, that does it for this week's introductory podcast. Let me know if you have any questions, and I will see you next week for a new installment of 5 Key Questions.